We're here today. We've invited small business owners from across the region to discuss a new issue. Recently in Louisiana, we've experienced an explosion of ADA lawsuits. Over the last 5 years, between 2011 and 2016, ADA lawsuit filings in Louisiana have increased by more than 36%. By and large, these lawsuits are targeting small business owners, restaurants, bars, shopping malls, property owners, even municipalities for very, very minor violations of the Americans with Disabilities Act. And so it's become a very costly problem. Small business owners need to be aware of what's happening in this field of litigation, and they also need to be very aware of what they can do, the proactive steps that they can take to protect themselves from litigation, and of course to be in compliance with the Americans with Disabilities Act.
How would you characterize these lawsuits?
Well, unfortunately, many of these lawsuits are what we describe as cookie cutter lawsuits. In some instances, the plaintiffs filing these suits are not actually patronizing or attempting to patronize the businesses that they're suing. They simply drive by and may discover minor issues in the parking lot as it relates to ADA compliance, and simply, and rather than going in and notifying the small business owners about these violations, oftentimes the very first time a small business owner is made aware that something is not compliant is when they receive a lawsuit in the mail. So very often they're cookie cutter type lawsuits. In some instances we have cases of what we call serial filers, so the same plaintiff filing the exact same lawsuit over and over and over again, just against different defendants. And too often these lawsuits, the purpose of these lawsuits is to extract quick cash settlements out of the small businesses rather than actually improve the accessibility of the restaurant or the small business. And so, which of course is totally violates the spirit of what the Americans with Disabilities Act is actually intended to do.
Our members are the job creators of the state. We have over 4,300 members across Louisiana in every industry segment of the economy. But small business owners make up probably 97% of the Louisiana economy. They're the private small business owners, family-owned businesses that are out there creating jobs for people.
What kind of an impact does it have on a small business when they're hit with a frivolous lawsuit?
For us, we watch these issues so closely because it does impact them immediately. A judgment against a small business owner can put them out of business overnight. And so what we try to do is really focus on what are the issues, where is the judicial climate going, and how can we protect small business owners. And so what we do is try to say to legislators, policymakers, let's not make it a positive environment for people to go out and file lawsuits. Let's make it a more business-friendly environment so that businesses can stay open, can keep employing people.
An example of what I think of as a frivolous lawsuit in this direction is where we have situations of individuals who are not even patrons of a business, who in turn engage in what I call a drive-by litigation tactic, where they effectively have no intent of being a customer of the business or even dealing with the business, but are simply trolling and looking for opportunities to find lawsuit fodder. They in turn file a lawsuit with no intent to patronize the business, and are simply doing so in order to create an opportunity for attorney fees and extract a settlement from the business owner.
What kind of settlements are we talking about?
The settlements can vary. It really depends on the nature of the claim, the extent of the issues that are targeted as being non-compliant with respect to the premises. You can be looking at something in the vein of thousands of dollars, most certainly $5,000 to $15,000 to $20,000, not counting the cost of what the plaintiff may be insisting the business do to improve the condition of the premises to make it compliant.
What happens to employees if the small business they work for is hit with a frivolous lawsuit?
I mean, it could range from anything from layoffs and not being able to having hours cut, or just the doors shuttering altogether. You know, for small business owners, they operate on such a thin margin that a frivolous lawsuit and a big judgment against them has a major impact on their bottom line. And so what we have to do is protect folks from that.
Well, frankly, the impact can be very devastating, depending on the resources of the company. But frankly, they are hit with not only the threat of litigation, but also the price of engaging their own counsel to defend the lawsuit, the cost of what is involved in settling it, making changes to the premises. And some companies can do that, and others can't. And we've seen examples, many of which have been reported on extensively in the media, where some companies have had to literally shutter their doors because they can't afford to weather the storm created by the lawsuit.
Good afternoon, everybody. I'm Dawn Starr. I'm the state director for the Louisiana chapter of the National Federation of Independent Business. Many of you are our members, and I want to thank you for taking the time out of your schedules to be here today. And for those who are not, we welcome you as well. We're very excited to be here. We're getting around the state doing a bunch of different roundtables, and Melissa reached out about partnering on this particular issue, and we're happy to talk about it. NFIB represents 4,300 small business owners across the state of Louisiana in every industry segment across the economy. So everybody from architects and engineers to builders to IT developers to farmers and everything in between. So our members employ roughly 175,000 people across the state, and that's just our members. And we know that small business makes up about 98% of the economy. So we're glad that you're here today. We'll talk about this important issue, and I want to thank Representative Polly Thomas for taking the time out of your schedule to be here today. Sorry, you just put a bite, but we're not going to make you talk. But we appreciate the legislative involvement and former Representative Luigi. I mean, you know this issue as well, and it's important to kind of bring the legislators and the business community together to talk about this stuff, be aware, and figure out how we can be proactive about changing policies that will help all these folks that are in the room today. So without further ado, I'm going to turn it over to Melissa, and then we'll go from there.
I'm Melissa Landry, Executive Director of Louisiana Lawsuit Abuse Watch. We are lesser known in the state than NFIB, but we've been around since 2008. We have about 15,000 supporters across the state. And so we're a 501c4 nonprofit supported by your generous contributions. And our sole focus in the state is we're working to improve Louisiana's legal climate. That's what we do all day long, every day. The report that's sitting right in front of you, ranking the states, was just recently released. It's a survey that was conducted by the U.S. Chamber of Commerce, ranking Louisiana's legal climate 50th. Dead last in the country for the overall perception of our state's legal climate. We are dead last in every single category, from plaintiff-friendly judges to judicial impartiality, out-of-whack verdicts, you name it, we are dead last on the list. Probably does not come as a surprise to you. Unfortunately, we have been on the bottom of the Chamber survey every year since its inception. Annually, we are also highlighted by the American Tort Reform Association's Judicial Hellholes Report, where they highlight jurisdictions across the country that are recognized and known as being the worst places in the country to be sued. And so we are also a regular regularly highlighted on that list as well. And so I point these things out to you not because we take delight in the bad news, but simply to make the point that unless, our leaders in the state, so, our leadership take, sort of recognize the issue for what it is and actually take action to address it head on, we'll continue to come in and rank on the bottom of these lists. And certainly, what has happened in Louisiana with regard to lawsuits, ADA lawsuits, is certainly a part of, why we have this negative legal climate. David Whitaker, who is a partner with Keen Miller, who is actively involved in these cases, is going to get into much more of the specifics of ADA litigation. But I wanted to give you a quick overview of what the numbers look like. So since 2013 to 2016, you can see there has been a year-over-year dramatic increase in the number of ADA lawsuits that have been filed all across the country. and to the next slide, the trend here in Louisiana pretty closely tracks with that. Overall, there has been a 36% increase in the total number of ADA lawsuits filed in Louisiana between 2011 and 2016. And in the next slide, you'll see the vast majority of those lawsuits have been filed by one single law firm. The Beiser Law Firm. If any of you all have been involved in any of these cases, you probably know the name of this firm very well. They are single-handedly driving, this trend in litigation in Louisiana, along with the help of a handful of very willing serial plaintiffs. And so, most often what we see in these cases is the same plaintiffs filing very, very similar copycat-style lawsuits over and over again, just against different defendants, oftentimes filed on the very same day. And the other trend that I would note that is apparent in the data is that the vast majority of these claims are settled out of court, and some, very often within a year. So it appears, just by looking at the data, that the purpose here is to extract quick cash settlements from these companies and not actually to improve accessibility, which is, of course, violates the spirit of the Americans with Disabilities Act. And just so before I turn it over to David really quickly, I'll just say, who's at risk? And the purpose of this slide is everyone. If you own a business, if you provide a service or a product, essentially you are at risk. And even if you just simply have an online business, there has also is a growing trend in ADA claims for violations that either mobile apps or websites are not accessible. With that, I would love to turn it over to David Whitaker, who I said is the expert in this field of litigation. He's tried many of these cases, and we are so very grateful to have him with us today and bring it and share his expertise with us on this topic.
I appreciate the opportunity to be able to speak to you guys today about a topic that unfortunately has become more and more of an issue for small businesses in this area. And we're talking about the Americans with Disabilities Act, specifically Title III of the Act, which imposes certain requirements on facilities that are places of public accommodation. We'll talk about what that means in a second. That I think every small business owner needs to be fully aware of. What I hope to do today is spend just a few minutes talking to you about what the ADA requires, what are the basic requirements, dispel a couple of the myths that I think have built up around this area in terms of the way businesses perceive their responsibilities or not having them. Then I want to talk a little bit about the litigation trend we've seen, and then kind of close out with some ideas that I would offer to you as things you can do to be proactive to minimize your exposure on this subject, which I think is, again, a growing trend that we're going to see more and more of as the years go by. And then after I've done that, I'll throw open the floor to any questions you may have, see what interests you, what curiosities you have, or concerns that you may wish to raise to the group that might, I think, further raise the awareness of everybody in the room about what this situation involves. In terms of the law, this is not a new law. Okay, this law was signed by President Bush, the first Bush. It became effective in July of 1990, July 26th, I believe. Title III of the Americans with Disabilities Act imposes certain requirements on places of, quote, public accommodation to make them accessible to persons with disabilities. And absolutely, is that a noble purpose? Is that something that should be part of our legal requirements? Yes, I think it is, and I think most people would agree with that. But as you'll see, as we kind of talk it out a little bit, the devil of the situation is in the details, okay? And there's some things that I think that were not correctly implemented or could have been addressed differently when this law was enacted to prevent there from being the opportunity for what I believe in many cases are abusive lawsuits that typically fall heavily on the shoulders of small business. A place of public accommodation, you say, what is that? Basically, any business that opens its doors to the public, allows the public to come in and conduct business, be it at a service counter or a restaurant or anything of the sort where the public comes into your place to receive goods and services or to participate in activities on your premises, those areas of your business are going to be deemed, for the purposes of this law, to be a place of public accommodation. The significance of that being the case is that you then in turn are required as a mandate of this federal law to make it accessible. And you say, well, what does that mean? How do I decide whether something is accessible or isn't accessible? I mean, do we have to look at that on a case-by-case basis, and what's accessible to one might not be accessible to another, and so on? Well, the good and the bad news of it is that the federal government is here to help. And no, really, they're here to help you. And what they've done, the Department of Justice has published some what they call guidelines for accessibility that literally detail in great technical detail every element that you could possibly imagine, running from the height of a service counter to the width of a doorway to the amount of pressure that needs to be applied to open a door to how high the mirror in the bathroom can be in your bathrooms, and on and on. Okay, so the good news is that there is guidance. The bad news is it's very complicated and very involved. And frankly, for a business to be fully compliant, I think you would have to have a new construction situation where you have a very competent and qualified architect and builder to try to make it as perfect as possible. But I will tell you that some of the matters that I've been involved in defending companies have been, in fact, in new construction. And we often engage our own ADA technical consultants, because I'm an attorney, I'm not an engineer, I'm not an architect. I have a good sense of what the requirements are, but we bring in professionals to really get down to the I's and T's on this stuff. And I had one of them tell me, this guy's literally done thousands of premises inspections in ADA cases. He tells me, I have never seen a 100% ADA compliant restroom, ever. Like, wow. I'm like, he said new construction is the worst, because they know better and they still get it wrong. Okay, so again, this is very complicated stuff. Some of it's rather basic, and there's some things I'm going to tell you about that I think you can take stock of yourself without necessarily having an expert. But all of this is to say there's a lot going on here, a lot of moving parts. Now, let me bust a couple of the myths that I think companies get in trouble in when they start looking at this situation. The statement I hear from companies all the time that get hit with these claims or looking for advice is they come and they say, well, wait a minute. You said that this act was adopted in 1990, right? Right. It says, well, wait a minute. This building was built in the 1950s. We're grandfathered in, aren't we? Aren't we? How many people think that you can be grandfathered in and not have to comply with this law at all? A lot of people believe that. Well, they want to believe it. You'd really love to believe it. In New Orleans, we have a rich history of old buildings and businesses that date back generations, and you'd like to think, well, do we really have to tear down and pick apart everything that we have here in order to be compliant with this relatively new, right? I mean, in a city that's almost 300 years old, right? These requirements. The answer is there is no such thing as grandfathering as an absolute defense to compliance with this law. There just isn't. Now, if you have a building that was built prior to the effective date, there is a somewhat different standard of compliance, okay, that gives you a little bit more leeway, but I will tell you that that is not, it's somewhat of a false hope. And what I mean by that is if you have a building built before the effective date of the act, you have to make your facility compliant to the extent it is readily achievable. What does that mean? Does anybody know what that means? Readily achievable? Well, again, we're getting into a wishy-washy legal term that can mean a lot of things. But what the regulations and the statute say is that you look at things like, mainly, what kind of resources does the company have? You making money? You have a good revenue stream? Well, gosh, readily achievable. You guys sure have a lot of revenue. We think a lot is achievable if we look at it that way. And do you want to go into court arguing against a wheelchair-bound plaintiff that, you know, my company that grossed $1 million last year in gross sales can't afford a $2,500 curb rent? It's not readily achievable, Your Honor. You think that's going to fly? It's not going to fly. That's not a defense, and you don't want to be arguing dollars with a wheelchair-bound claimant or a blind claimant or something saying that we can't afford to do this. That's not going to be a winning argument. Now, that said, does this mean you have to take an old building and tear it down and No, you don't have to tear down an existing building. You don't have to rebuild a building from scratch. And there are some situations where, based on the architecture, construction principles, and in some cases just outlandish cost in the tens or hundreds of thousands of dollars, where you can make out a case that it's just not feasible with this footprint of this building in this location, short of tearing the whole thing down and building it over. The law isn't going to make you do that. But again, it's a very slippery slope, and I wouldn't get too hung up on the readily achievable thing. I've only had a handful of cases that we've dealt with where I felt like, you know, that's an item we'll go to war over, and I think we can win and use it as leverage. Very few cases where I felt very strongly about that. So the other myth I want to bust is how many of you guys are business owners where you have leased premises as opposed to a building you own? Okay. A lot of times the operator of the business looks at this and says, wait a minute, that's the building owner's responsibility. Look, I'm just the tenant. I'm just a little guy in here running my shop, and this is the landlord, it's his building. They can only get after them and on. Incorrect. The way this law works is that the ADA plaintiff can sue the operator of the business, the owner of the land, and the owner of the building. They can go at all, two, one, all three, whatever they want to do. And they typically will go after multiple parties. Where you're going to have to look at that is in the standpoint of looking at your lease. If you are the owner of the building and you're leasing to somebody, or conversely, you're the tenant, a good, well-written lease ought to talk about whose responsibility it is to ensure this compliance, right? Well, let's say that you're the tenant and your lease says landlord responsible for making sure the premises are compliant with law, including the Americans with Disabilities Act. Does that mean that you in turn can then respond to that ADA lawsuit by holding up your lease and saying, not my responsibility, go sue these guys? That doesn't work either. Okay, again, the plaintiff can get after all involved, the owner, the operator, as many parties that are involved in the situation. So please don't fall into that trap of thinking you're safe on that basis. So, what have we been seeing in terms of lawsuits in this area? As Melissa has pointed out, we've seen a major uptick in the number of cases filed. And in fact, I think I probably defended the very first case that Andy Beiser filed, and his firm filed. When he first started out, it was him and him. He didn't have a secretary, it was just him. Andy comes over from Florida. Okay, I've been to lunch with this guy a few times. I've talked to him and gotten to know him a little bit. Nice enough guy, pleasant. You wouldn't mind having a drink with the guy. But he comes from Florida, and he worked for a firm that did nothing but this. In states like Florida and California, this litigation is rampant. And the reason for it is under the federal law, all the plaintiff can get you to do is, number one, force you to make the changes to the premises, which can in some cases be expensive, and they can go after you for attorney fees. And the attorney fees, I believe, are mainly the driver for this litigation. It's the profit motive for it, let's call it, right? But worse yet, if you're in a place like California or in a state like Florida, those states have their own state laws that mimic this ADA requirement, except for one thing. Every time the plaintiff goes to the premises and is denied access because it's not accessible, he or she has a claim for money damages for their mental anguish, pain, and suffering of like $5,000 a crack. And they can go back as many times and claim denial as many times as they wish. And so on top of everything else, now you've got these mounting damage claims. It's just, I just don't see how any business can survive that kind of claim. Fortunately, you don't have to worry about that here because those kind of mental anguish damages aren't in play under the federal statute. So that's the good news for us here. But notwithstanding that, Andy has made quite a niche for himself. He's filed more and more suits, and then he hired an associate, then he hired 2, then he hired 3, now he's got 4. I mean, he's grown quite a practice, and congratulations to him from an entrepreneurial standpoint, right? I mean, we can at least admire that, right? But that's what Andy and his firm does, and what we're also seeing now is that the Visor firm has not got this market totally cornered. We're starting to see other firms come in from out of state that do this kind of work, and they come hang out their shingle here. And then we're also seeing other kinds of plaintiff attorneys who haven't really done this kind of work in the past, starting to get interested, filing one here, filing one there. And so that's what we're seeing. In terms of the nature of this litigation, look, there are some cases where people who are customers of your business who come in, and those folks are genuinely desirous of coming in and having access to your business so they can enjoy the goods and services. And look, that's the law, right? And you'd be well advised if you have somebody that comes to you and wants to present a problem to your manager, to the owner, whatever. Hey, I'm having trouble getting in. Or there's not an accessible parking space for me. Or, hey, you know, I come in here every time, the counter's way too high, I can't pull my wheelchair up and conduct business. Would you do something about that? You'd be well advised to take those concerns seriously and deal with them. But in many cases, what we're talking about with this litigation is what I'll call the drive-by plaintiff. Literally the drive-by plaintiff. These people are repeat litigators. They file suits over and over and over, some of them 2, 3, 4, 5, 10, or 12. And when you look into it, what you find out is this person really what I would call a legitimate customer, a legitimate patron of the business, who really believes they've been denied access. No, they're not. No, they didn't. Have they bought anything? Do they intend to? Or are they going to really return and do business with you? The answer is no. They are there because they see an opportunity. They create an opportunity by filing a lawsuit and then want to hang you out to dry for that opportunity and inflict a settlement on you, which can be for tens of thousands of dollars in terms of modifications you may have to make, as well as thousands of dollars in attorney fees that these attorneys are going to be demanding. So that's kind of what we're seeing. It's kind of a drive-by, file the suit, try to settle it, and the like. So what, you know, the question is, what can you do about it as a small business owner? And I've got just a handful of things that I think you ought to consider. The first is I think you want to get educated about what this act is and generally what it requires. And there's a really good resource put out. It's published by the U.S. Small Business Administration. You can find it online very easily. Just Google SBA, Small Business Americans with Disabilities Act. You'll pull this up, PDF format. And this guide does a great job of educating you to the what I would call some of the real basic core requirements of this act. What do you have to have in terms of accessible, handicapped accessible parking? What are the dimensions of the space? How does it have to be marked? What kind of signage do you have to have? What are counter height requirements of the act? What are some of the requirements you have to have an accessible access from the parking lot to your front door of your business? A lot of these questions are addressed here. And the reason why I think this is an excellent place to start is because when we talked a minute ago about the concept of the drive-by litigation, I literally mean it. They literally go drive around and they're looking for opportunities, and the way they do that is they look at what I call a business's external calling cards. What do I mean by that? Well, if they're driving past a place of business, they can see your sign. It's a company of some sort, and they can probably gather from the sign whether it is a place where customers come. Okay, well, they've got that figured out. It's a business. It's a place of public accommodation. Well, what's the first thing they see? Well, if they see a jacked up looking crumbled parking lot with no handicapped accessible spaces, ooh, pull the van over. Let's go look over here. They love strip malls, by the way. You know why they love strip malls? How many businesses are in a strip mall? How many suits can you file over a strip mall? You can sue the individual businesses, you can sue the owner, you can sue the leasing company, the management. I mean, you can sue 5 or 6 people out of this, right? And go to each one and say, well, you know, you just pay me $5,000, and that adds up kind of quick, doesn't it? They love strip malls. So they see your parking lot, they see no signage, then they pull into the parking lot. And what's the next thing they see? They see that you don't have an accessible curb ramp leading from the parking space to the walkway that runs in front of your business. They're even more interested. Now the claimant, the drive-by plaintiff gets out and he wheels his wheelchair up and now gets onto the access path to your front door. Man, did you see the slope on that sidewalk? That's not compliant either. And then they want to come inside. And they'll just roll right in and see that you don't have an accessible service counter. I mean, the counter maximum height is supposed to be 36 inches. Yours is up here. They look around. Is there handicapped accessible seating? No. And where do you think the next place they go? Huh? Bathroom. Bingo. You win the prize. They go running for the bathroom. And why is that? Because of all the areas that you have to comply, they may have to go to the bathroom, that's possible, okay? But of all the areas of compliance, that is one with perhaps some of the most ticky-tacky, detailed requirements. And they know if they go in your bathroom and it's not a new construction, they're pretty sure that they're going to find something there. And among those is the requirement that there be at least 5 feet of clear floor space within the bathroom. And that's a requirement designed to allow wheelchairs to be maneuverable within a bathroom. And then, of course, if you have stalls, we have different requirements with the width of the stall and the height of the door latch and grab bars for the toilets and all of that. Excuse me. So, you know, the bathroom is a treasure trove of ADA violations. They go in there, and then wham, bam, they come out, and now they've got a laundry list of things to sue you over. And that's how this goes. So my best advice for minimizing your exposure is to, if you're going to start by focusing on any place in particular, focus on the exterior calling cards. Look at what you've got in terms of a parking lot. Look at what you've got in terms of the handicapped accessible parking space. This guide talks about, depending on how many total parking spaces you have, how many of those have to be handicapped accessible, what kind of signage, how wide, how do they have to be painted, you have to have at least one van accessible, you have to have access, I mean, all of that, and they can see that curbside. Look at that, look at your curb cuts, the lead into your front door. If you do those things right there, I think you've lowered your profile significantly. Doesn't mean you're perfect, you may have a lot of things going on inside that need to be addressed. But start from the outside and work in, and I think you do yourself a tremendous benefit by approaching the issues that way. Outside of that, I think what we really need to have, and I know there have been some efforts to accomplish this, is a legislative solution. And I've seen a number of efforts to try to amend the act to make it what I would think of as better and more directed toward the actual purpose of the law. The main change I've seen people propose, legislators propose, is an idea that before the plaintiff can file a lawsuit and get the attorney fees rolling and all of that, they have to make a demand on the business owner or operator to try to address, you know, in an amicable way, hey, look, these are the particular issues I'm having. I'm asking you to address these to make them compliant. Will you do so? And then the owner has so much time in which to respond. Either yes, I will, or no, I won't, or no, I can't, or yeah, we can't do that, but we can do this. In other words, a response. And if that's not worked out and the facility isn't compliant, well, I mean, at that point, do you deserve to be sued? Yeah. I mean, at that point, you are not compliant with the law. You've been given a chance to become compliant. You've blown that opportunity. At that point, it's kind of a shame on the company at that juncture. But we don't have that right now. And the way this law works right now, they do their little survey work, and then it's immediately lawsuit city without having to let you know anything other than the fact that you've been sued. The other thing I would also commend to you is if you do run across one of these issues, you receive a lawsuit or you get a threatening letter about a potential lawsuit, take it seriously and get capable help. Because really trying to understand what your position is on the front end, what you can maybe do to defend yourself, knowing that early on is critical. And I've seen a number of situations where small businesses have gotten tangled up in one of these lawsuits. They didn't get good help to respond. They end up trying to work with the plaintiff attorney, and that just leads to it being worse. This idea that, oh, we'll just let them come in and they can bring their people in to inspect us and tell us what we need to do, that isn't going to lead you to anywhere except a bigger number, okay? And I've had a few come in after they've already kind of done that, and it's like, well, you know, you're kind of in a pickle right now, and I wish you'd have called me earlier. So those are some things that I would suggest to you, and hopefully we may see a legislative solution that changes the act to align it with what I consider to be more of the true purpose. The purpose of the act isn't lawsuit and attorney fees. The purpose of the act is to bring companies into compliance and provide access, and I think that ought to be the case. But I think there's a better way of doing that. And hopefully we'll see it, but you know, I have my doubts, because does anybody know what the single most powerful lobbying group is in this country? Trial lawyers. Trial lawyers. They will fight this to their dying breath, okay? And because of that degree of influence, you're going to have a very hard time getting this law changed, but it doesn't mean it shouldn't be tried, and maybe it one day can pass. So that's my take on it. Does anybody have any questions, or has anybody had any experience with this they might like to share or bounce a question? Position being taken that if you have a website, company website, and you're holding out your businesses and services on, you know, on the internet, cyberspace, right? Is your website a place of public accommodation? Does it have to comply? Is it a digital virtual storefront that has to comport with the requirements of the Americans with Disabilities Act? You say, Whitaker, what are you talking about? People aren't walking into my cyberspace store. I mean, they're on their computer and they're pointing and they're clicking and hopefully pointing and clicking and entering credit card numbers and seeing amounts of sales and all of that, but they're not coming into my website. This isn't the Matrix or anything, is it? I say, well, no, that's true, but the way the theory goes is that if I'm a person who's deaf or blind, do I have full enjoyment and access of your webpage, your customer portal, your virtual store? Do I or don't I? And if I don't, if you just got, you know, called run-of-the-mill website, well, no, they don't, because they're blind and they go to your page and they can't gather any information. We say, what the hell? How am I going to get? How are they going to? They can't see the screen. In this world of wonderful technology, we have technologies that allow a person with a browser for the blind, so to speak, where their computer and their web browser will effectively describe to them the content of your web page. But your page has to be, to my understanding, encoded in a format that supports that technology. And if it's not, that's your fault. And therefore, your site is not accessible to the blind or to the hearing impaired if you have audio-visual sounds and, you know, you got, you know, clips of people talking about how wonderful your product is or some other information that you want your customers to know. Well, you know, are there subtitles to that readily available by viewing your web? Again, that's what's going on. And you literally see, this is crazy, and not all courts have agreed with this. Some courts looking at this have kind of looked at it, I think, as you or I would. And they say, no. When we look at place of public accommodation, we think that what the act was getting at was places, bricks and mortar, physical, you know, buildings, sidewalks, handrails, things you can grab and touch. It wasn't intended to encompass this sort of digital reality. And so you have some courts that just kind of take that and throw it out. But some courts have kind of shown an openness to that, and some courts have allowed that kind of case to proceed. And what you see are these, I kid you not, there are these law firms that will go out, and they don't do it, they hire a tech company to kind of be their survey guru, if you will. They go around and they find websites that aren't compliant with this access technology, I'll call it. Then they file these massive lawsuits against thousands of companies on behalf of one person. Pay up. You know how much it's going to cost you to make that website compliant? A lot, potentially. Why don't you just pay me $20,000 and we'll call it even?
And I'll give you 3 years to get it done.
And I'll give you, there you go, I'll give you 3 years to get it compliant. That's a pretty good scheme. I mean, that's pretty, I gotta give it to them, that's pretty good. But that's what the new wave is. Now, we haven't seen a ton of that here, but we do have a client or two that has, not where the suit's been filed here, but where the suit, and that's the other interesting thing. So you got like Louisiana businesses, and you say, okay, you know, maybe the courts in our federal circuit, the Fifth Circuit, don't really cotton to this idea of, you know, lawsuit against a website. But you've got places in California, Ninth Circuit, and some other liberal circuits that do, and you say, well, man, I'm feeling pretty good that we're not going to get hit with this kind of suit. Not so fast. What they say is the plaintiff who's in California who can't access your website from his or her home there, well, by having your site on the World Wide Web, you've effectively created personal jurisdiction and venue against your company wherever the plaintiff lives. And so we've had some clients who've been served with suits where they are sued, not Louisiana federal court, but out in California or out in Vermont or Illinois or what, and they're like, can they do this? We're still trying to figure that out. It's not cut and dry. So it's a scary world out there when it comes to this kind of stuff. And you know, when you see the number of cases where this is being tried, it really is a little discouraging.
Would you consider this a cash grab?
I think in some instances it is. You know, certainly Louisiana Lawsuit Abuse Watch and our partners at NFIB, and I would suggest the vast majority of small business owners in Louisiana across the country absolutely fully support the Americans with Disabilities Act, as we all should. Everyone is in complete agreement of the mission to make our world accessible to everyone. The problem here is, you know, some plaintiffs' attorneys who are using this very well-intentioned law simply for the purpose of extracting settlements out of mostly small businesses.
We'd like people to really consider the fact that we are not against regulation, or we are not against protecting consumers and employees and everything, but we have to find that fine line, and we have to make an environment in Louisiana that isn't friendly to lawsuits, and currently that's the environment we have. It's a bad for business, and we want to change that.
The vast majority of small businesses in Louisiana simply cannot afford to fight costly litigation. You know, most small businesses are operating on very, very small margins, and so being hit with a lawsuit that could, you know, run in the range of $10,000, you know, to $20,000 simply for legal costs is a threat that they simply most small businesses can't afford. So it can be very, very devastating to small businesses in terms of the way that they are able to hire other employees or to reinvest in their businesses or even buy additional equipment, you know, to enhance their services.
And my best advice for the owners of a small business would be to get educated, to understand that the Americans with Disabilities Act does impose important legal obligations regarding your premises. Get involved, understand what those are. Don't assume that it doesn't apply to you simply because your facilities predate the effective date of this law. And then take steps to proactively make your premises compliant. And I think if you take those steps, eliminate the major issues you may have at your premises, that'll go a long way to keeping the drive-by litigation at bay.
We're very encouraged by the number of folks that came out on the small businesses in the region to learn about this issue, and we are continue to be very encouraged by the support of folks across the state for a Louisiana Lawsuit Abuse Watch and the growing call for legal reform in Louisiana.
If people have questions, like more information, what should they do?
Absolutely. We would love for folks to learn more about us at www.law.org. They can also find us on Facebook or Twitter at Reform Louisiana.